Welcome to this special show on Aadhaar. It's indeed a historic day because the world's largest biometric ID database has been constitutionally upheld by a five-judge bench of the Supreme Court. Now, it's not a complete victory though, because even as the Supreme Court bench upheld Aadhaar, it has struck down many sections, and it's also made the nature of Aadhaar more voluntary rather than mandatory. In fact, we caught up with Aadhaar architect Nandan Nilekani in an exclusive interview just a few minutes back. Listen in to what he had to say. We have Nandan Nilekani, the architect of Aadhaar, joining us live and exclusive on ET Now, all the way from the US. We've been troubling him for many hours now, but finally we've managed to secure a line with him. Mr. Nilekani, thank you so much for talking to ET Now on a historic day as this. In a sense, it started all with you the moment you came on board at UIDI way back in 2009. Take us through your first sense of this verdict, the majority verdict that came out from the Supreme Court today, upholding the constitutional validity of Aadhaar.
I think this is a landmark judgment in favor of Aadhaar. And I think not only the court has, upheld the constitutionality of the act, they have unequivocally validated the founding principles of Aadhaar, which is that it was a unique identity project that was critical to the development goals of the nation, that it was all about inclusion. It was about millions of people who didn't have a proper ID having an ID, and it was very much a resident-centric project. And I think they have upheld that. I'm very grateful for that. And I think they have also made a lot of recommendations, all of which should be looked at. And I think this essentially, through this, almost a decade-long process, I think we have developed a better and stronger Aadhaar together.
Right. Sir, but while a majority of the bench upheld Aadhaar, Justice Chandrachud presented a very strong dissenting view where he raised questions on the way it was passed as a money bill. While I know that rests with the Parliament, he also made some very scathing observations on the Aadhaar program itself. He also questioned the UIDI's ability, to safeguard citizens' privacy. What would you say to all these concerns? Is this work in progress? Are there many things that still need to be fixed?
I think the judgment is a 4-1 majority judgment, and I think it has upheld the constitutional value of Aadhaar. And as I said in my previous remarks, Aadhaar has gone through 10 years of, a lot of feedback and improvement, and I'm sure they will continue to do that.
Right. Mr. Nilekani, I just want to touch upon, the scope of Aadhaar. Are you a little disappointed with the fact that many sections have been struck down? I mean, they have retained Section 7, which has to do with subsidies. They've also made it mandatory for PAN and IT returns. But many things for which Aadhaar was being sought, be it mobile phones, banks, school admissions, so many other schemes, it's now not mandatory. Net, are you okay with that? Are you disappointed that perhaps the scope of Aadhaar has been limited to a large extent? It's been clipped to a large extent. This is a diluted version of Aadhaar.
Well, I think first of all, it's a very long judgment, and hundreds, probably 1,000 pages. So we'll have to go through it and study the fine print. But I do believe, my understanding is that if it's voluntary usage, there should be no issue. If I want to use my Aadhaar for a service, I don't see any issue. So I think all this will get sorted out. I mean, fundamentally, I think it's a landmark victory for the Aadhaar case. It's been constitutionally upheld. The Aadhaar Act has been upheld. Everything. I think it's a great moment, and we should look at that.
Right. No, I'm sure it's a tactical victory because, ultimately it's not been scrapped, it's been constitutionally upheld. But I'll just ask you one more point here, which is Section 57. This is something a lot of startups, private companies were looking forward to. That has been read down, Section 57, which has to do with private entities gaining access to Aadhaar. The court said that that is unconstitutional. But, others say that there is a provision wherein if it's backed by law, private companies can still access it. How would you read this Section 57 in particular, sir?
Over the days, a lot of clarity. Any use of Aadhaar for benefit of a billion people will be possible.
What do you think is the way forward from now? Because the government has, the court has said that the government must push forward with a data protection law right away. Do you believe that needs to be done? Is there political will considering elections are still a few months away?
Well, I don't know about the job in putting together a draft. I do hope it will get passed as soon as possible.
Right. And Mr. Nilekani, in a sense, do you feel vindicated today? Because the last few years, there's been a lot of criticism on Aadhaar. There have been particularly some strident criticism coming from activists on its scope, on security, on exclusion. Do you feel vindicated today as someone who, architected this project? I mean, in that sense, do you feel vindicated today, sir?
Well, I think, right from day one, the Aadhaar project was a vision of inclusion. It was about giving millions of people who didn't have an identity some way to have an ID access services. So it was a very inclusive vision with a lot of passionate and dedicated, idealistic people. And I think that the fact is, I think the Supreme Court has upheld that vision, and we are grateful to the court for their sagacity.
Right. Finally, sir, do you think there should be more done in terms of, a regulatory structure for the UIDAI? This is something that we asked Justice Sri Krishna as well. It was recommended in the Sri Krishna Committee report that there needs to be a regulatory structure as far as the UIDAI is concerned. It can't be the judge, jury and executioner. Do you think there should have been more clarity on this, or, is this an evolving process? We will see more on this.
No, I think that question is linked to the data privacy law, because the data privacy law in turn will create the architecture for a data protection authority, and that data protection authority, will be sort of the overall oversee the data protection and other issues. So I think it's all, you have to think of this as part of the infrastructure of privacy that is getting created in India today.
Right. Mr. Nilekani, last question to you, sir. In the last year or two, you've also been pushing the idea of India Stack, wherein the platform of Aadhaar can be leveraged for a number of use cases, be it eKYC, e-sign and others. But with today's judgment, particularly the one on Section 57, do you think it will be a longer process for that to happen, that perhaps the pace of adoption, whether it comes to fintech, whether it comes to private sector, is going to take longer than expected? There will be a lot of pain points there.
Well, as I said, we have to see the fine print, and it's really premature for me to comment on that. I think it's entirely, we just have to get into more details, and I'll leave that discussion for another day. Okay? Thank you, Chandra.
Right. Big voice there, Nandan Nilekani, but it doesn't end there, because we also have Justice Sri Krishna, who headed the Committee on Data Protection. We caught up with him as well to understand his views on the verdict. Justice Sri Krishna, I want to start by getting your take on the judgment today. What do you make of it net-net, the fact that it's been constitutionally upheld with a 4:1 majority?
Well, Supreme Court has taken the view that although there are a lot of difficulties with the Aadhaar issue, they have been able to overcome most of them and held it to be constitutional, except a few issues on which they have agreed that it is unconstitutional and struck down the whole thing.
Sir, but do you agree with Justice D.Y. Chandrachud, who said the passage of Aadhaar Act as a money bill is a fraud on the Constitution, that it should not have been passed this way?
I don't know the other views, I have not had the benefit of looking at it, but on the money bill part, I am also of the same view. But then that's a minority view, the majority has taken the opposite view.
Would you say then, sir, that this is perhaps a middle ground approach, that while it's upheld it constitutionally, there are also a lot of checks and balances, it's struck down many of the problematic sections, it's made a lot of services non-mandatory. Would you say this is a balanced verdict in that sense?
Yeah, absolutely. You see, that is the approach. There can always be two extreme views on any issue. The job of a judge is always to find out a balance between two extreme views. And truth is not necessarily binary. It's something to be achieved so that all interests are served. It's not a question of philosophical truth finding, it's a question of practically solving an issue that was presented to the court. On the one hand, the court was of the view that Aadhaar was necessary. On the other hand, it found that there were some difficulties which had to be removed. They have attempted it by taking the middle ground.
Right. So, how do you read Section 57, which bars private entities from accessing Aadhaar data? I mean, does it mean that it completely doesn't ban them, that it changes it to a voluntary nature, rather than a contractual process?
This section enabled private entities to compulsorily ask for Aadhaar. Now, that has been removed by holding it to be unconstitutional. So, it is open to the citizen. Citizen may say, I will give you Aadhaar number. Citizen may say, I will not give you Aadhaar number because there is no obligation on me. The law which obliged me to give you has been struck down by the Supreme Court. That's exactly the implication of striking down.
Sir, does this also mean that the government will have to push ahead faster with the data protection bill, considering that came up in the Supreme Court judgment today?
Till the law is passed, nothing. The situation remains where it is as a sequel of the Supreme Court judgment.
Are you disappointed that there was no mention of a regulatory structure for the UIDI? Because in the Sri Krishna Committee report, you mentioned how there needs to be a regulator for the UIDI, increase their powers of enhancement. Should there have been more on that?
Yeah, unfortunately, from what I have learned so far, Supreme Court has not addressed the issue of an absence of a regulatory or monitoring mechanism under the Aadhaar Act. That was one lacuna that we observed, and therefore, if you look at the annexure to the report, we have said, although it is directly not within the remit of the committee, we have suggested that it can be strengthened on the following by the steps being taken by the government. That seems not to have been addressed at all.
Thank you so much, Justice Sri Krishna, for joining us on a very important day like this. We'll take a quick break at this point, but don't go anywhere, because on the other side of the break, we have Sahil Kinney, a former venture capitalist, now an entrepreneur and an Aadhaar expert, who will join us and tell us about the impact that this is going to have on the private sector and startups in particular. Welcome back to this special show, and we have Sahil Kenny with us right here in the studio. He's an entrepreneur and also an Aadhaar expert, considering his background, the UIDI. Sahil, overall it's a positive verdict because it's upheld it constitutionally. The sections related to subsidies and PAN stays, but bad news as far as linkages to mobile and banks and other things are concerned. But more importantly, section 57 has been read down, which means private companies cannot access Aadhaar. As a startup entrepreneur yourself, what kind of impact is this going to have? Because Aadhaar was seen as a big tool for, eKYC, especially for fintech startups. What impact is this going to have?
Well, actually, Chandra, that's a great question. I at this point remain optimistic because the section has been read down but not struck down. And the part that has been read down particularly is that the part of section 57 which allowed private companies to seek Aadhaar by contract, which means purely on the basis of an agreement between the private party and the individual, has essentially been declared unconstitutional. But the comment says nothing about voluntary use, nor does it say anything about usage of authentication when it's backed by law. And this was a clarification that our Finance Minister, Mr. Jaitley, issued during the cabinet briefing somewhere around 3:30 this afternoon, where he said that his interpretation and the government's interpretation would be that this is a restriction but not a ban, and private entities can offer Aadhaar authentication as one of the means of identity verification. They just can't make it mandatory. So as far as I understand it, I remain optimistic that most legitimate and regulated use cases will continue unaffected.
Right. There is a particular line that says, this is clearly impermissible as a contractual provision is not backed by a law. So, Arun Jaitley in his press conference mentioned about how, if it's backed by law, then private entities can potentially access Aadhaar. So, should we expect some legal provisions here, some amendments that the government will introduce in this respect, that it's, that the doors are not completely closed as far as the private sector is concerned?
Well, the regulations already issued by the RBI, SEBI, IRDAI already recognize eKYC as a valid KYC, and these regulations have groundings in the Payments and Settlements Acts and a couple of other corresponding acts for the other two regulators. So as far as legal backing is concerned for electronic KYC, that already exists. I believe that legal backing will only be strengthened and clarified further once the data protection law that has already been recommended by the Sri Krishna committee kind of takes effect after it's been voted into law. So I see a formalization happening, and I see people getting more clarity on how and where Aadhaar KYC can be used for business purposes, and I don't think that it's going to be overly restrictive as long as it's backed by law.
Right. Lastly, Sahil, what does today's what does today's judgment mean for the whole vision of, the JAM Trinity, Jandan, Aadhaar, mobile? Mobiles are no longer, mandatory. Aadhaar, many of the provisions have been read down, and Jandan, it's not compulsory for bank accounts anymore. What does the JAM Trinity really mean after the verdict today?
Like I said, despite the slightly morose tone of your question, Chandra, I remain optimistic. The fact that we've opened 300 million bank accounts in the last 4 years is an unmatched feat globally. Whenever I go elsewhere in the world and I tell them about what we've done with Aadhaar authentication and financial inclusion, which is something that is expressly mentioned in the judgment, by the way, that Aadhaar is a tool for inclusion and empowerment. And that's precisely what Jandhan was. Aadhaar, of course, continues to be held as constitutionally valid. Everything about it, from the way it was passed to its core principles, stand validated right now. And as for mobile linking goes, again, this is going to be, linking is not mandatory, but if you want to get a SIM card, the fastest way to this day remains Aadhaar eKYC, where you go and give your authentication and you get a SIM card that's active in 3 to 4 minutes. And I don't see people giving up that kind of convenience anytime soon to go back to the dark ages of paper, where getting a SIM card meant 3 days or 4 days of waiting.
Okay. All right, Sahil, on that note, thank you so much for joining us on this special show. And with that, we come to the end of this special coverage on Aadhaar. We got you all the top voices, all the insights and perspectives that you need to know on this historic verdict. Thanks so much for watching, and stay tuned to ET Now for more news and updates.